attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions and anything that I've said during the trial, not evidence. All right, so if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when Circumstantial evidence is when no witness can testify directly about the fact that's sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses, all right? It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying, and whether the witness displays any bias in testifying, and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which she's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right? Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts. All right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? We said, so I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that. All right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling this, I'm not suggesting you'll have one, but if you should do the following, all right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring it back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process accounts for, may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop, and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing. Send me a note and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone. All right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. And then while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating. All right? So no subcommittees in a sense. What you do as a group. All right? You do it all together. Now I'm going to get to a difficult part. Reducing and sending out the jury. All right? When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12. All right? And so the way it's done is the clerk will draw the alternates' names. We put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, they would have to substitute one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. So as I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations, and it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14.
what I kind of forgot to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callum Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation, or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. There's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know that we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest, respectfully, that you each approach it with a mutual respect for the opinions of your fellow jurors. That you have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident they'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
While we're on this brief break, thank you for sticking with us. Tim and I are going to get to full analysis in just a moment. Obviously, there was a major issue with YouTube. If you see a bloody stump, it is me chewing my hand off. No one is exactly sure what's going on. I'm not moving on. There were multiple channels across YouTube who suffered from this. Good thing Tim Jansen knows the #1 media attorney in the country, and I'm coming for you guys. It's my kids, it's my livelihood. Don't mess with my channel. Did absolutely nothing wrong with my kids. It's my livelihood. I care about this biggest moment in YouTube, and these other people got to get crazy and start flagging channels. And I will get to the bottom of this at the appropriate time. Will mess with my livelihood or my children. I will come for you. I will come for you. Okay. This is all about Cora, Dawson, and Callan. They're going to send the jury out in a moment. I will try to not chew my hand off too much. Tim Jansen, I don't want to get completely into it because I want to wait for this to break completely, and also Steve Cohen may get us another guest or two, but just general impressions aside from the disaster that is YouTube. And I'm not going to mention the other media entity, but I will make it very well known to them at the appropriate time that SDS doesn't mess around, and I'm coming for all of you.
How long were they out? The YouTube was down.
It's not clear. Not clear.
Because we kept seeing it. I never got interrupted from the trial.
Yeah, we never got interrupted either, but on their end, they did. And I really apologize, obviously, most to STS Nation, completely out of control. Look, Mark Zuckerberg announced they have to pay $14 billion. You can't operate businesses on algorithms alone. Screw AI, screw algorithms. You need human beings. That's just the way of the world. You still need human beings, and I will get to the bottom of this.
Speaking of which, Joel, just hopping on here. Hi, everyone. It's the COE.
Hi, COE. Yeah,
since you guys both had the stream the whole time and it wasn't taken down from you, and you guys were able to hear that, please give us your analysis and your take on both sides. Thanks so much.
We will. However, COE, also, can you send me, I'm going to tweet out a link so everyone knows.
Yep, you have it in your text messages already.
Yeah, Melissa Navone knows how to really soothe me and calm me down. She's like, wow, you lost a lot of viewers. Right? We lost all our viewers because of this platform. I'm not going to harp on it anymore.
Did they ever come? Did they come back up? Are they back on?
Yeah, we're back up here.
So right now, Joel, they're at sidebar because they're putting on the record whether both parties agreed to the instructions that were sent to the jury, right? What happened in the Markel case? They didn't object to the instructions, and if you don't object, then you waived them. So he's doing that preliminary work there, and then they're going to make sure all the proper exhibits get sent to the jury. That's what they're doing at sidebar.
Okay, and now once the jury is back there and settled, it's 12:30. Typically, they take lunch. Are they going to have? And we're going to get, by the way, into all the minutiae of the closings. Tim and I were able to listen to absolutely everything, and I took some copious notes till the stream started being affected, in which case my blood pressure spiked too much. I'm trying to breathe and bring it back down here. But Tim, just what do you think? Is the jury going to go on a break?
No, they'll go back into the room, and then they're going to probably order lunch, or they may have lunch ordered for them. But they'll start deliberating once all the exhibits.
Each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed, that you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God. As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God? I do. Thank you.
All right. The jury, you may now retire to consider your verdict. Thank you.
Court, all right.
So the alternates aren't allowed to leave. They keep them, and they're not allowed to talk about the case in case something happens with a juror. So
where are they actually? Where do they hold them? And they hold them for the duration of the deliberations?
They can keep them in a conference room. They can keep them somewhere where they keep them in a hotel room. and someone's got to be with them so they don't talk about the case.
Interesting. Okay, so let's just see.
All right, we could be seated.
Verdict clock is beginning right now. We're at 1 second. Kevin Reddington still standing.
I just wanted to
Let's
make
listen
one comment. It really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing. It's intellectually challenging. It's physically exhausting. So I just wanted to commend all three counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
COE, can we please, they're going over a couple of the exhibits. It was very nice of the judge, His Honor William Sullivan. Interesting body language there for Dr. G. She's got her arms crossed, Lindsay Clancy. But they're just going over some of the evidence that the jury will be able to see. COE, please keep in mind that Kevin Reddington is going to be absolutely bombarded if he walks out of the courthouse. So just keep an eye on that in case he makes a few comments right now. I'd like to take that live as if there's not enough going on. I also, as the judge of STS here, want to thank the COE Space Coast. If only you could see our text while this debacle played out with YouTube.
And when she walked in the hospital and she knew she was
me screaming
what
like
she did was wrong, she said she felt horrified. And then
Space
while
Coast
still
is just tweaking some of the things here. I just want to thank the COE, Spacey, who's always working his magic, and Steve Cohen, who's trying to rally up a few extra guests right now to come in to break down these closings, and Space Coast trying to pull up the correct feed here, but they're essentially deliberating as we speak, and we are on verdict watch. Now, I'll just give you my 2 cents off the top here, bird's eye view. I thought, obviously, both sides vigorously defended the side that they were representing. I actually think that the Commonwealth may have presented a more clear and concise closing argument, whereas Kevin Reddington bounced around a little bit. At times, it was a little difficult to follow him, and he was much more emotional. The Commonwealth, I thought, was much more streamlined, but you generally see that from prosecutors. They're just a little less emotional in general, and I think Kevin Reddington is very heavily invested in this particular client of his, the defendant Lindsay Clancy. He went for 54 minutes, and I believe Jessica Sprague, with the assistant district attorney, went 52 minutes. But Tim, your overall thoughts about these closings? We are now in verdict watch. The minute we get a verdict, we will bring it to you.
Well, I'm confused why the Commonwealth waited until the closing arguments to make their case. Jennifer Sprague did a brilliant job outlining why the district attorney made these charges, outlined every reason why they believe she committed this crime. She was able to undercut the experts. She even undercutted Resnick, the red flags, and she went line by line. And I thought she did brilliant. I think she may have turned half the jury with her closing argument. Well, I was thinking maybe a not guilty or maybe insanity or maybe a hung jury. I think her closing was strong, and I think it's going to resonate with a lot of those jurors because she outlined and had evidence, and she did it very casual, wasn't screaming, wasn't emotional. And I liked the little thing when she picked up the quarter and took the challenge from Resnick and gave it back to us. So kudos to Jennifer Sprague.
Reddington. I think you said Resnick, but you mean
Red-
Reddington was putting his
Red-
quarters down. Yeah.
Yeah.
So we just got an exact time here from Julia Rock, Love STS Nation. 51 minutes and 53 seconds for Reddington, to be exact. And the Commonwealth was 55 minutes and 40 seconds. And they said they would be under an hour, and both were under an hour. It was just, look, I could be a juror, and I'm not saying right, wrong, or indifferent. It was much easier for me to follow Jennifer Sprague. It was here we go, from this point to this point to this point, whereas Kevin Reddington sort of bounced around. But I'm also not that smart, so I need something a little more straightforward. Now, there is a poll here with 4,877 votes. If I make it through this day, it will be an absolute miracle. I don't know that I will. But criminally responsible of murder, 28%. Responsible for manslaughter, 8%. Second-degree murder, 5%. And not criminally responsible. This has been, this is you guys. This is not STS, but this has been fairly steady with substantially more seeing her as being not criminally responsible. The judge here is a gentleman. Look, no matter what your feelings are, this is a very difficult case to try for either the Commonwealth and or Kevin Reddington. They did a great job. I'm glad that the judge acknowledge them. So let's get to Kevin Reddington, and we're going to do a full wrap-up show at 5 o'clock today, and Steve Cohen may bring in a couple of people right now, and we are on verdict watch, and we will obviously bring it to you the minute we get it, and would not be surprised at all to not get a verdict. I mean, Tim, would you be surprised at all if we don't get a verdict today?
Oh, I don't know if we'll get a verdict today. I mean, you're talking what, 4 hours?
They would have basically 4.5 hours.
I don't think they'll get a verdict today.
Yeah, I don't think so either. Now you see the chat is split already. Andre R or Andre AR, 100% guilty. Whew. Kevin is the GOAT. We've been split like this the whole way through this trial, very divisive trial. So the Commonwealth, let me see here. Let me get up to my notes on Kevin Reddington. Those were the DA. Let's start there because Kevin Reddington went first. There was no rebuttal. It was just straight through Kevin Reddington. He began at 10:02 a.m. You are looking, I believe, at a live shot of the great Commonwealth of Massachusetts, the seal for the great Commonwealth of Massachusetts. And when there is either a question or a verdict reached in the trial of Lindsay Clancy, we will bring it to you live. Kevin Reddington got up there, Tim Jansen, sort of soft-spoken, and said it was about 5 weeks ago that we met like this, and took a good amount of time to thank the jury for their incredible service. You took more than a month out of your lives, and you had to go through some of the most gut-wrenching things a person can be subjected to. You've listened, you've been fair, you've been objected, and you've been consistent with a very solemn oath that you took. I mean, Tim Jansen, do you try to acknowledge jurors and thank them for their service before you get into the meat and potatoes of your closing arguments?
Of course, you want to get personal with them and thank them. It has been a long, grueling time. And he's trying to say, listen, I thank you. Trying to get personal with them. I think the prosecution did the same. It's not inappropriate. I think he did that. And then right after he did that, what did he do? He attacked the cops in the front row. He tried to deflect and say how many cops and DAs you have sitting. And there were a bunch of guys. It wasn't just media in the first two rows this time. So he knows what he's doing. He did have a theme. He said it was, his theme was manipulation. In this case, his whole theory was manipulation of the evidence. And then he went on to show how it was being manipulated. And that was his theory. And every defense lawyer should have a theory of their case, why it was brought, and describing why you believe there was manipulation. And that's what he did. He went down the line.
I will be surprised. Someone said deliberations through next week. We live in an instant society. Everything comes to you on Instagram and TikTok, and sometimes it comes to you on YouTube when they're not destroying you with their algorithm. However, I can't see them going over the weekend. It is very possible. I personally don't see it. They have roughly 4 hours today, and they will have a whole day tomorrow, and I think they'll come to some sort of conclusion. They might get an Allen charge, which we'll get into in a minute, but this comment is interesting. Leave it up for a moment, COE. CW totally won me over, although I was pro-red previously, followed by CW was outstanding. Prayers for Cora Dawson Count. Listen, I think almost objectively, it was a much more coherent, cogent closing than Kevin Reddington. They just put all the pieces in a straight order and went through them. Go ahead, Tim.
And they clearly showed why they filed these charges. I mean, they went by piece, by witness, every fact, why they believed it was what she was doing. They undercut what Kevin was saying, arguments about she was offered 3 choices and she turned them all down. Yeah, she was given medicine, but not really a lot. And at one time only using, so they really did I've got to give her kudos because I had questioned and concerned about them. She cleared it all up and she gave it in a very clear, concise, white hat Commonwealth. We are here. This is why we're here. She didn't dangle all the pictures and do for emotional. She proved her case and she made her arguments. And I think she won over a couple jurors.
Yeah. So Miss Quish says, thank you, Tim. Can someone explain all the verdict options? I'm going to run through it real quickly. Essentially, there's murder 1. She goes to prison for life if found criminally responsible. Yesterday, they put a manslaughter charge on the table. If they come back with manslaughter, it is much, much less time. If she's found not criminally responsible, she will likely go to a psychiatric hospital. That's where she is now. It's called Tewksbury Psychiatric. And she will then be followed by a judge and medical experts to see if and when she could be released. Andrea Yates, I believe, committed her drowning of her 5 children in the early 2000s, and she is still in a psych hospital at her own request. The other very odd possibility is a mistrial. They can't come together, and then she would remain at Tewksbury, and if the DA tried her again, there'd be another trial, and if not, she would essentially become a free woman, which is the strangest of all the possibilities. But so Kevin Reddington opens up and he thanks the jurors, and then I thought it was smart and shrewd of him. He literally says the names of the 3 children: Cora, Dawson, Callan, and then pivots back. Not an acquittal. There is no acquittal here. There is a mistrial. If the jurors cannot come together on a decision, that is a mistrial. Then she would remain in the psychiatric hospital, and then it would just depend on whether the DA brings another case. If he wants to try her again, she'd be tried again. If not, that is the scenario. If there's a mistrial and they don't try her again, she could essentially become a free woman after admitting the killing of her 3 children, which is a real crazy outlier, but it's in the cards right now, at least the way I understand it. And again, this is incredibly divisive. She deserves to rot behind bars, guilty, period. I'm curious, were any of you swayed, besides the one comment we saw, were any of you swayed by the Commonwealth's closing argument today? Were you on the fence, and now because of the closing, are you in favor of the Commonwealth, or vice versa? Were you swayed by Kevin Reddington? I don't know. So, Tim, right after thanking the jury, he does invoke Cora Dawson and Callan's name, and then points to his client and says, look, she knows loss. It was a weird line because she caused the loss, but when you look over there, Lindsay, Clancy, was crying. He says that the kids are the victims of this case, and then pivots to there is no proof beyond reasonable doubt, and therefore
Right.
there is doubt. And then goes back to him, and this is where it was kind of all over the place. So he goes from the kids to Lindsay, and then goes back to the kids, and then goes to reasonable doubt, and then says, this is a prosecution that has ripped the soul of this girl. Interesting. He referred to her as either a girl or a kid, and that wasn't unintentional.
Right.
What do you think he's trying to do with the use of the word kid and or girl for an adult woman here?
Well, he's trying to argue that she's young and emotional and did something horrendous, but she's just a young girl. She's not a young girl. She's a mother, and a nurse, and educated, has education. Yeah, he did. He tried. I thought it was smart, showing the pictures of the family and how much she loved them, and she was a great mother. And then he had to give an answer. How could you go from this picture to this picture? And he did that. He tried to say lousy medical and lousy meds. So he blamed the system because it was lousy meds and lousy medical care that caused this happy photo to where we are today. And he's putting the medical system and the doctors on trial instead of his client. That's what he's trying to do.
This is important, Tim. There were originally 12 women and 6 men, 18 jurors. It's now been whittled down to 12, and we are 9 women, 3 men. Women are notoriously tougher on women. What do you think of that breakdown? We don't know ethnicity, minority, age, any of this, but
Right.
9 women, 3 men. Who do you think that favors?
You know, you're right. Women judge women tougher. But on this single issue, seems like a lot more women are more conciliatory towards Lindsay than the men are. Who was the foreperson? Because the judge picked that foreperson. Do we know who that is? Have we able to determine if that was a male or female?
Not yet. I think we'll find out, but I don't know.
Yeah, the foreperson can really sway a jury. They can have a little mind control and have a little authority figure that sometimes they can guide the jury. It's a tough call because of the nature of the case here. If more women will be better or worse for her.
Tim, what about this? This question is for me, but it's really for you, from Christina. What would prison look like for Lindsay? She's obviously in a wheelchair.
Right.
I understand she won't be thrown in there with no resources. What kind of assistance do you have in a state prison system? If you are in a wheelchair, she's said to be incontinent, which means she can't control her bathroom issues. So what kind of special accommodations are made, if any, in the state prison system?
Well, you know what? This might be a case where they contract out with the federal government and they send her to a federal medical institution that can provide her the medical and still be a prison system. Sometimes these people are shipped from, like Markel, they were shipped out to Hawaii, right, or Colorado as a contract between them. And you could do the same because I don't know what facilities the state of Massachusetts has for an inmate that has these severe medical issues, constraints in a woman's facility where that you can't just have prison guards unless they just kept her in a medical wing of a hospital. And I don't think they're really equipped for that. But like Butner, North Carolina has a federal medical mental health facility. They might contract and make up space for her there.
Imagine going to a prison mental facility. It would probably be one of the scarier places on earth. When I got a tour of where Brian Koberger is, there was a block for the mentally ill, and it was straight out of one flew over the cuckoo's nest.
Like Hannibal Lecter.
Yeah, it was some scary.
Yeah,
it was scary stuff. So, Tim, we are learning now the oldest woman on the jury is now the foreperson. Foreman described as an older woman. Interesting. It's not always an older person, but here it appears, if STS is right, it is the oldest woman who was in this jury pool. By the way, I think the oldest person was a woman, was someone in their 60s. It wasn't an
Right.
overly old jury pool.
Right.
But what about that aspect? That it could be a 60-something-year-old woman who's now going to be, quote unquote, running the show for the jurors.
Well, she'll probably be very organized, seen a lot in the world, lived everything, might have kids, grandkids, and she might take to what the prosecution did and outline why they got to how they got here. Now you still have the experts, you still have to get through beyond a reasonable doubt that the mental health issues didn't, and the government has, the Commonwealth has a heavy burden here. They got to prove she killed him, then they got to prove beyond a reasonable doubt, then they got to prove beyond a reasonable doubt that she didn't, she had the mental to know what she was doing. Those are three big burdens, and beyond a reasonable doubt, it's a really heavy burden.
Tim, we're not there yet. It's called an Allen charge. If they have a hard time coming to an agreement, the judge can try to force their hand a little bit. How many times can a judge send jurors back to try to deliberate? How many times can he do it?
As long as they want. And I was going to argue that the judge gave kind of a modified Allen charge in the jury instruction, telling him that you're the best jurors, that you can make this decision, keep, even if you don't believe, hold your position, but consider others. That's basically the Allen charge. They don't normally do that in jury instructions. And I thought it was a little paragraph in there to help them, giving them confidence that they can reach a verdict. So he's letting them know we're counting on you to make a verdict. But
Look at this, Mandy.
is a tough case.
Yeah, I'm currently locked out of a regular chat. I apologize, Mandy. I'm going to add that to the list of points on my impending lawsuit against every single tech company in the world. I'm going to sue every single company simultaneously. Every one of them. I'm putting them on notice. If you own a tech company, I'm coming after you. I am looking at a live shot of a lot of microphones. It looks like they are waiting potentially for Kevin Wright. The prosecution is not going to talk till there is some kind of verdict, and then it's questionable. But it looks like they're waiting for Kevin Reddington to come out, and the COE and Spacey are keeping an eye on that. Annette seems to say that the older jury foreperson, and I'm not sure how anyone knows this right now, is 67. Someone else is saying 62. Or the people here, or I guess they're giving their own ages. I'm not sure. Kathy's saying for some reason, everyone is providing their age today, it looks like. Needless to say, this woman is going to be, I think, in her 60s, the jury foreperson. And there you go. Tucker's got my back. Thank you, Tucker. Can't run a company on an algorithm or AI.
Hey, we like people in their 60s. They're the smartest people.
They are the smartest, and they're the tannest people with the best hair. So, Tim, let me ask you this: in your own experience, I mean, the world's watching this. What do these jurors do first? I mean, they're going to talk to each other. They've been talking to each other, but not about the case. What do you think? I mean, how does this play out? You think the jury foreperson takes control, says, okay, let's sit down. And what do they look at first, if you had to guess?
Well, normally, and I've talked to jurors, and we had a juror on there from Katie McDonald's trial. We said, what happened first? And the jurors all sat down, and then the foreman said, okay, let's just take a preliminary vote, secret, and see where we are. And they handed pieces of paper out. And they did a secret vote to see what the breakdown was, to kind of see where everybody was, break the ice. And that's a pretty good way to see how people are and make them have input, get them involved, the other jurors, make them write something down. And then you go from there. Then you get the evidence. They're probably going to be ordering lunch. And then they're going to say, okay, let's all go around and say points that you think, or what exhibits would you like to hear, or stuff like that.
Tim, you're okay, but you were breaking up a touch. So if we lose Tim, I'm just going to call it a life, I think, and just shut the laptop, and you guys will never see me again. But hopefully he'll stick around. You're looking and sounding good now. Do you think the manslaughter charge, Tim, and there's a lot to go through here because I took a lot of notes, but
Yeah.
Tim, do you think the manslaughter charge can be the tiebreaker here? That sounds like reasonable in the middle. And it's interesting because manslaughter is essentially saying, yeah, she did it, but we want to take it easy on her. What do you think?
Well, when I heard the instruction and the way it was written, and I'm a lawyer now, I don't really think manslaughter is relevant here. I don't think it applies because I think either she did this with premeditation or she heard this voice and she didn't know what she was doing. If we can't get a verdict and if it's deadlocked and it's out for a long time, and then they get an Allen charge and then they come back, they could come back, like you said, and say, okay, we'll agree to manslaughter just to split the baby. But I don't think they'll come back with manslaughter initially.
All right, so they're gonna obviously pour over all this evidence, many exhibits. The judge was going through some of that. Back to Kevin Reddington's closing argument. So he mentions the kids and he kind of circles back to Lindsay Clancy, but he then comes back to the children and says that they are the victims of this case. And I think that's something that he had to say. But then he turns to the prosecution, and he did this in the opening statements and once again in closing arguments. And he says that this is a prosecution that has ripped the soul from this girl. Once again, using the word girl. One of the things that has come up, Tim, is that Kevin Reddington is a little too passionate about his client, a little too enmeshed maybe. What happens when you get emotionally attached? Has that happened to you where you get kind of emotionally attached to a client and it I don't want to say extends beyond, a client attorney relationship, because I'm not implying that at all, but I think he really cares about her, probably looks at her as a daughter figure. He's a son about her age. And can you get too close to a client?
Yeah, you can. And you can get emotionally caught up because you're so entrenched in it that you make decisions and say things that you probably shouldn't say. I think he is emotionally caught up with Lindsay. I think he's very close to Lindsay. I think he kept the boundaries, but he is clearly cares a lot for her. And he might knock the jury off by calling her a young girl, putting his hands on his shoulder. Remember, she killed her children. And so they're thinking at him, okay, why are you so friendly with this murderer? Our question is whether she was sane or insane. But yeah, he's gotten too close to her, I believe.
Yeah. Gia and TJ's mom, and we sort of addressed this. He does call her a kid and a girl many times. And Gia, I'm going to leave this comment up, but Gia and TJ's mom, Tim, why do you think Reddington kept calling her a young girl or a kid? Isn't that strange at all? I think that my opinion is that he actually views her exactly that way. It's like his own child, and that's what he, but I think it was also a subtle message to the jury that this, even though she's in her 30s, she's a young woman in a horrible situation. Please have mercy on her. What do you think, Tim?
It could be both. He's 75 years old. Him, a 30 something, or how old is she now? 40 something. He could. Yeah. She's not a young girl, obviously.
No, she was in her late 30s when this was going on. So she might be 40 now.
Yeah, she wouldn't be called a girl by someone unless you're a grandfather, right? And maybe he is trying to garner some sympathy with the verdict, with the jury, by calling her a young woman, a young girl. And sometimes he's old school. He doesn't want to mess up by saying the wrong verbiage, so he says young girl instead of young woman and whatever. But it's a subtlety for sure.
Yeah.
He knows every word he says is purposeful.
Yeah. I think he is very deliberate with the use of his language. So after saying that this is a prosecution that ripped the soul from this girl, he now walks over. We talked about demonstratives and exhibits, and he takes a family picture from Facebook. And he says, this is what they had. And it's the typical picture you see on Facebook or Instagram where everyone's so happy and the life's fantastic. This is their family. And how does it turn into this? And I believe he held up some sort of autopsy or evidence photo.
Hey, Joel, can I take a break for a second? Just for 1
yeah,
second?
yeah, please go for it. Tim Jansen, duty calls. What a day this has been. I'm not going to spiral. I could easily spiral. The COE got me a massage for my last birthday, and I never used it, and I just might have to go and use it today. I think, I mean, I'm not going to get overly dramatic. I'm not going to get hyperbolic, but I could have a brain aneurysm. It could be the end for me. You ever watch Sanford and Son? And it was, this is the big one. This is the big one for me. Tim appears. Tim, you're back. I was just saying.
Some guy at the pest control drove up and was looking at me and pointing at me. So I wanted to let him know.
This is why I love podcasting. You could never say that on CNN, but here you can talk about the pest control. We got the Orkin guy that comes all the time, tries to poison my dogs. Tim, so he holds up these demonstratives. He holds up a Facebook picture and then some sort of autopsy photo or something from the evidence, the crime scene. How effective is that for Kevin Reddington?
I think he had to hit it head on, because I think he knew that the Commonwealth was probably going to do it. He couldn't ignore it, but he's making his case that she was a loving person except for the medical and the meds. And that's his case. And so he had to do it up front and make them look at it and then listen to him. And I think it was smart. He had to do it. I don't know how effective it's going to be. It's really weird because in Massachusetts, the defense goes first. In Florida, the prosecution goes first, and then the defense, and then they get a rebuttal. You end up with the prosecution and here the Commonwealth speaking last, which is a big advantage, because then you can attack and respond to everything that the other side said. Kevin didn't get a chance to stand up and respond. And, a lot of people, sometimes they make decisions based on the last person they talk to.
Yeah, well, I can deal with Fred or relate to Fred Sanford in a big way today. I'm coming to join you, Elizabeth. Coming to join you, Elizabeth. And today, if I was ever going to go join Elizabeth, today is the day. What a great show. That way, they don't make TV like that anymore.
No.
New member here from Fun 85 UK. I could have said P Hun, but I think it's Fun. Tim Jansen, so he says, how does this turn into this? Wilderness saying that Reddington was scattered. I agree a little bit. He had some notes. First, I thought he was going up there noteless. He wasn't in a particular order. He did bounce around from point A to G, then G to C, then C to L. You get the point. But he says, how does it turn into this? Like, how does it go from so bad? And then he says it was the damn medicine, the lousy medical care. Interesting point, Tim. He had done this during the course of the trial, not quite as explicitly, but here he is putting the healthcare system on trial, saying, you as jurors, you got to understand, she was over medicated. She was on 13 medications, which I don't think he know. I mean, I would have mentioned that number. I don't think he said that. And she got lousy medical care. Did he bring that point home enough about the damn medicine and the lousy medical care?
Well, I think he did. And remember, his whole theme was manipulation. He challenged the jury. He goes, watch the manipulation. He asked them to do something, right? You always want to get the jury to do something. So he says, watch the manipulation. And then he went down and was describing the manipulation, right? He brought in some of these doctors that don't have any experience in psychosis. They were underplaying the suicide attempt, the fake suicide, as he said. He said, and he kept asking him, look objectively. And then he had to explain the Google searches, right? I think he didn't do very good there. I know he had to address them, but I think his response to the Google searches, I think didn't play. And I think they weren't reasonable.
This is where it got a little, I agree with that. This is where it got a little like just odd. So after the lousy medical care, he kind of just saunters into, look, you can pay as many experts as you want. You can have all the experts in the world up here, but it doesn't necessarily mean they know anything. And segues from there to the, one point there was talk about chicken McNuggets that she was making, I think, for the kids or not. And he goes, you could be making chicken McNuggets. You could not be making chicken McNuggets. And then goes into, we as the defense and the defendant, you don't have to defend against anything. So it was almost like a stream of like what I do. Like this guy was not focused. Mm-hmm. And I think for this closing, he really needed to focus. Monkey here, I liked how the prosecution used his quarter stunt against him, which Tim pointed out. I thought that was smart, actually. He left the quarters there and she picked one up. But
Joel, what else did he do? He had challenged and attacked the police investigation, mm-hmm. right? He had to do that because the police really didn't do a great investigation. And he challenged them. He brought up things, the evidence that they didn't, and did all that because he's got to poke holes somewhere because sometimes the facts were against him. Clearly the facts are against him. And so he then manipulated to no investigation, the pill bottles, who crushed him, why didn't they grab him? And then he brought up the wish box or whatever. And then he went into Tufts too. So he was all over the place. Like you said, it wasn't clear. It wasn't concise. It didn't lead the jury to believe, okay, he's showing us how he got to where he is. He's all over the place. And I think if Joel was here, Professor Joe, she would tell you, this is like an exam where you just throw out everything you know. It's garbled. It's not concise. It's not clear. Sometimes juries miss it.
Yeah. And I feel like, you always hear, it's a leading question in during testimony, but here I feel like this is your opportunity to really lead them into your theory. And I don't know that he did the job that he needed to do in arguably the biggest moment of his very long and storied career. I wonder if he's thinking this himself. I'm curious to see. There's a gaggle of microphones and media out there. We'll see. He might not talk till there's a verdict, and then I think he will. So all of a sudden he goes from we don't have to defend against anything to the burden is on the DA, Tim Cruz, who he does not like and made it known, and the assistant DAs, who, of course, are in the courtroom. They have to prove that at the time of these killings, that Lindsay was not suffering from mental disease or defect. I thought that line was obviously important, not that, creative, but it was important because you heard several of the Commonwealth witnesses, expert witnesses, just say that she was suffering from mental disease or defect. It wasn't, she was suffering from psychosis. They just said she was suffering from mental disease or defect. And he just clearly states that. Now, if a juror goes back and says, wait, the threshold is just that they had to be suffering from mental disease and defect, I might just say, well, even the expert witnesses for the Commonwealth said that. So let's give her not criminally responsible. Again, Tim, this is a very nebulous line. This is not clear cut. And it's not dependent on psychosis or not psychosis. I think that's going to be tricky with a jury.
Yeah, I really thought that he was going to hit their experts more, especially the line where he got their own expert to admit that the Commonwealth's closing or opening statement was not correct. And he never brought that up. He never offered that to the jury, that I read the opening statement of the Commonwealth to their own witness, and he disagreed and said there's more to it than that. He never brought it up. And I would thought for sure that was going to be in his closing. I don't know what he was trying to do, but you're right. The most important thing is the burden that the Commonwealth has. You thought he would have written that down and focused on it a lot, because that's a really high burden. He spent a lot of time attacking the experts, the pill bottles, but he missed some of the stuff that I thought was right in his wheelhouse.
Yeah, we're joined now by John Day. If you don't know, he's also a former prosecutor and criminal defense attorney. John, can you hear us?
I can.
All right. I don't know if you had a chance. Can we drop that lower banner, COE, or get rid of the verdict clock so we're not cutting? There we go. John, did you have a chance to watch closings?
Just lost your sound.
All right. It's been one of these days. I'm going to bounce him out and have the COE. John's a fantastic criminal defense attorney. We'll try to have John come back. So, I mean, Tim, so after this, mental disease or defect comment, he literally his sarcasm comes out and he's like, yeah, just give her a couple of pills. She'll be all right. And he takes a very sarcastic approach. How does sarcasm play to a jury in a very heavy case like this? Did he need to be more literal, I guess?
Yeah, if you're asking the jury to let someone go of murdering 3 kids, you've got to lead them down a line that they feel comfortable with, the road with objective evidence and not just sarcasm. I mean, cross-examination is one thing. You can make a witness look bad, make some points, and that's great. But when you're tying it together and you're putting this purse together, say you're making a purse, you better have everything attached properly, the handles look good, and everything, so when someone's going to buy it, hey, this is a nice thing, it's all put together. He was all over the place. And he had lots of points, but I just don't think he made them as effectively as I think we all assume. We've all put him on a high banister because he's done so well in cross-examination. But I was kind of disappointed in his closing.
Yeah. Here's hey, John, you have us?
I can hear you.
Yeah. So, John, we're just going over the closing arguments. I don't know if you had a chance to watch them live, but a lot of people feel that that Kevin Reddington was a little scattered, not as streamlined as the Commonwealth. Your thoughts?
From what I saw, that seemed to be accurate. You wonder what would have happened there, but also I was reading some accounts that said some of the jurors weren't totally attentive during the Commonwealth either. So I don't know what that means anymore. I don't know what that means anymore. I mean,
and John Day, to you, the jury is now deliberating. We understand that it was the oldest woman. There are 9 women, 3 men who have been chosen. The oldest woman, said to be somewhere in her 60s, is the 4-person. Any thoughts on picking the oldest woman among the women to now lead? Do you think that a person like that, gut instinct wise, will have a little more empathy towards someone like Lindsay Clancy?
Yeah, again, I mean, what's the conventional wisdom on that? Is she going to be more empathetic, or is she going to have a side that's more judgmental? I mean, we'll know, but she obviously will have authority in there if that's how they selected her, and that's probably all along she's been the one who's given off that aura of authority, which is why they picked her. So I don't know. I mean, I do think that I was thinking that Reddington was going to have a stronger presence in this, and I think it seemed from what I saw that the Commonwealth's been a bit weak throughout the thing, but the image that they're sending him back with is 3 dead children, and that's a hard one. That's a tough one to get out of their heads in spite of it.
Joel, maybe this is a case where Reddington has been so good that he underperformed, and the prosecution has been so poor that when they made cogent arguments clear and made their case, they look like they won, even, makes them look better.
Yeah, John Day, I don't know how you approach closings. At first, I didn't see any notes, and then it appeared he did have some notes, but he seemed, I don't want to say underprepared, but he didn't have the focus on the closing that I think he needed to have. How do you approach it? Do you go in there with notes, or do you ever wing it?
I mean, I try not to wing. I mean, there's sometimes when you know it, you can go in there and you know it, but you've got a structure, you've got something, you got some type of a framework. And again, I think Tim's point is right. If the prosecution has lowered I mean, if their expectations are so low about these prosecutors, and they close competently, and they seem to be significantly more focused than Reddington, that could be a problem. But if you're the jurors and you haven't been terribly impressed by the prosecutors, and then all of a sudden at the end of it you say, well, it's not terribly exciting, but they laid out a story. The problem still is that they can't explain it other than find her guilty. I mean, they can't give them a closing. They can't go from A to Z without the default being she's so ill that we can't find her culpable. But we'll see.
Yeah, that's interesting. John, I'm just going to keep you muted because there's a little echo when you're not talking, and I'll take care of that. But Tim, I mean, John brings up a good point. They very openly admitted she was depressed.
Yeah.
Even saying that even alluding to the fact that the experts said that. And again, like, I keep harping on this, but I think it's really important. Like, if I was a juror, I'd be making this point. It doesn't say anywhere that you have to be psychotic. That's just something that's been manufactured by, I think, all of us, is this notion of psychosis, and the fact that their expert witness for the defense is an expert in that. But even if she was just very depressed, isn't that potentially enough to find her not criminally responsible? The argument the Commonwealth is making is that you're depressed, but you still know the difference between right and wrong.
Well, I think the prosecution did hit that head on and described all the action she was taking, the limited time frame, how she made these appointments, how she was acting that day, how she got them to go on these trips, how she was going up and down the stairs, how she killed them separately in separate rooms, like things like it was methodically done because the oldest kid would have stopped it if he saw something. So they made a good case showing that. I'm just surprised that Kevin didn't more talk about Patrick, and a little bit about her she couldn't speak, that they relied on what he told her, and that the timeline he was talking never matched up, how he was able to send text message, he didn't really focus on that. And I think he made more general arguments about the case than highlighting facts that the jury could listen to and tie to and say, okay, that's why I agree. I'm going to base my verdict based on fact. He was more general, attacking the system, attacking the investigation, and that they couldn't prove it. And that's not an easy thing to do when you got 3 dead children and a juror who's trying to do the right thing.
Yeah. COE, I don't want to give you more to do on a otherwise disastrous day from a tech perspective, but Calypso and others are asking for the verdict clock. If there's any way to stick it up there on the right, right there. There you go. 48 minutes of deliberations. Huge thanks, by the way, to the mods too, who are dealing with all that. There was just a disaster on the YouTube side of things that is completely out of our control. But John Day, let me unmute you and ask you, what about this manslaughter charge that was included just yesterday? Is that a place where you think all these jurors could land? Is that a viable possibility?
Oh yeah, you're giving them, it's an out, it's an off ramp. If you're concerned about whether you've landed it with the jurors, yeah, perfectly decent idea to do. No problem with it. If the jurors need something, if they can't bring themselves to say, the ultimate verdict on this with this woman, yeah, it's carving out an exception. It's giving them a way to feel okay about what they're doing without excusing it. I mean, that's pretty standard. I can't, the juror interviews after this are going to be fascinating to see how everything, how it went. But, I think that, again, if you're looking at this, the odds of a hung jury, I mean, I think it's pretty high. I don't know what Tim's experience with or thoughts are, but
Yeah.
It's very likely.
I still think it's going to be a hung jury.
Yeah, Tim's been saying that from day one. I mean, Tim, back to the closing
Although I thought the
argument.
prosecution made up a lot of headway today with their closing, I still think it's going to be a hung jury.
Yeah. So Tim, as predicted, because we saw this, I think yesterday, Kevin Reddington goes into she was a great mother, and then he pulls up another demonstrative. It was a Facebook post where she wrote, "A son, my prince."
Yeah.
How important is that to show that prior to this, and at one point he mentions, look, she never had a problem in her life. She was never in trouble in her life. How important is it to hammer home that she was this loving, doting mother prior to all this?
Well, it is important because you don't have to show a motive, but really that's in essence what he's doing is like, she's a great mother. She's never harmed her kid. She loves her kids. Why would she do this but for the lack of medicine on these voices? And he's given them a reason to say that's why she did it. And that's what he has to hammer because the kids are killed and she did it. And now he's got to explain it. And he's going to harp on that. And I think that's what he harped on. But, you know, the jurors, no, 3 children were murdered. And when they go home to their families, their grandkids and their wives and spouses who may think they're guilty, they're going to have a reason to explain what their verdict is or lack of verdict.
Good point. John Day, when he holds up this Facebook post saying, "Son, my prince," he then pivots and goes, "She killed him because she didn't like him." That's what the Commonwealth says, and that is repulsive. And goes into this theme that comes up again and again during the closing, where he says, "I told you, watch the evidence and watch the manipulation." The word manipulation came up at least a half a dozen times. Obviously, it is purposeful. But what is the purpose of using that word manipulation?
Well, he wants the jurors in the deliberation room to be aware, thinking about why the prosecutors have done everything that they've done. He just wants that word sticking in their minds. He doesn't really have to elaborate too much on it. He wants them suspicious. He wants them skeptical. But at the same time, he wants them also to be thinking about, as you said, the good mother thing. I mean, he had to do that. That's the smartest thing he could do, because that provides the link that if you're a juror who wants to acquit her, that provides the explanation as to that's so illogical, that's so irrational, it's so inhuman that there's no other explanation. He wants to shut off the prosecution's exit for that issue. I mean, he wants to say, because she was a good mother, we all know that, there's no other explanation that you can take back into the deliberation room.
I'm going to try to wrap the Reddington side of this. But Tim, he says, you can see from the evidence, the injury she suffered, slitting her throat, slashing her wrist. He always says that she threw herself out of the bedroom window. Others think she slid. And then he pivots. I think this was a good point here. He goes, and the slashed screen, screen. He says it twice, and then he goes, "Oh, wait, my bad. She thought she slashed the screen. That's called a delusion." Thought that was a very good point in the closing, because it illustrates that she thought she did something that she didn't do and maybe was in a state of delusion. Your thoughts on him bringing that in, Tim?
I thought it was good that he brought that in because he got one of the experts, even the Commonwealth experts, to admit after surgery, intubation, as major surgery, you can have delusional thoughts, say things that aren't reasonable. And then what did he bring up? He brought in The Shining with Jack Nicholson, right? and he brought that into the jury to show another crazy movie that most of these people, some of those jurors probably have seen. They probably still see the face of Jack Nicholson. So I thought that was clever. But and then he went back to the beyond a reasonable doubt, and he talked about them having handcuffs on her at the jail, about the lawyer. Remember, do I need a lawyer? Do I have a lawyer? He was trying to make the case of all this stuff's going on. They're asking her these questions. three years after, these doctors want to tag team her and get her to say things. You can't really trust them. And I really thought he for sure was going to bring up the point where he got their main expert to admit that the Commonwealth's closing or opening was not reality. But he didn't bring it up. Remember that cross yesterday?
Mm.
And he didn't bring that
Yeah.
up. And I thought that was a key point that he should have brought up.
Interesting. Rhino Girl, huge thanks. Gifting 20 Surviving the Survivor memberships, which will go to all of you. Then John Day, let me come back to you. They were arguing, he says, that it was a fake suicide. He just calls him out on it finally. Kevin Reddington, that it was this dinky, he used the word dinky suicide, sliding down the house. Remember that one, he says? You know, that's not what happened. She made a very significant suicide effort, and then goes on to say she was Googling the slitting of her throat, suicide, drugs, ketamine treatment, a list of medications. He just calls out the Commonwealth and said it was a legitimate suicide attempt, trying to evoke some more empathy.
Yeah, and then the jurors look over and they see her sitting in a wheelchair every day. I mean, they've got the evidence that they need if you're agreeing with Reddington. I mean, that's pretty strong, compelling visual evidence that, if you want to back them up on that.
You know, the other thing, Joel,
and then
jury instruction basically told the jury she's not going home no matter what. That one jury instruction said she'll be sent into a facility. A judge has to have a hearing. The prosecutors. So he's given the jurors the knowledge she's not going home either way. Either you find her guilty or not guilty because of mental. She's not going home. I think that's big.
Someone says they hate Friday deliberations, but it's probably going to happen. Tomorrow is Friday. John Day, another thing he brings up, there was this talk, there was like a hushed tone over the courtroom when we found out that she was, quote unquote, drinking. And he says they tried, the Commonwealth, to assassinate my client. She wasn't drinking while she was pregnant or had kids. It was back in 2019, and she might have had a few beers with her friends, and then at some point, I don't exactly know why, the judge reined him in and said, counsel, address the jury, please. I don't know if he was looking over and kind of taunting the Commonwealth at that point. What does it do during closings to be sort of reprimanded by the judge?
I mean, a lot of the time you don't want it. That to me seems relatively harmless, especially if he's making a point about the prosecutor's conduct. You're trying to convince the jury that these people are not kind people, and I don't think that would have hurt him if he was looking at the prosecution table. The jurors, they want moments like that at this stage in a trial. They're okay with heartfelt, genuine emotion. And if it crosses a line and he gets reprimanded, they know exactly what he was doing, and I don't think it hurts him.
Yeah. Tim Jansen, to you, he also makes a really good point. He says, look, my client, Lindsay Clancy, was religious in her obligation to take care of her health. She was a nurse. She was a wife. She was a friend. She's a mother. And he's reminding people at the same time that this is not a defendant. You look at the Adelsons, they're shady people, Charlie selling steroids, all kinds of unkosher things happening. But this is a woman who, by all accounts, was a perfect mother and a perfect wife, whatever that means, prior, and I don't mean just wife, perfect husband too, whatever that means. But there was nothing in her past. She was a high achiever to indicate that this would happen. The jury's got to chew on that, and they're probably going to say something had to go wrong, because this is a mom who loved her kids. I mean, isn't that a great point by Reddington there?
Those are great points. Those are his strongest points, is that she functioned well. She was a good mom and a good person, but something happened. Something went amiss. And what was it? And then he goes back to postpartum, going to these doctors. They're not giving meds. They didn't work. It's another doctor. So that's his strength. Why would she do this? Why would she flip to be the perfect mother to kill the 3 kids and kill herself? Something has to be going on. And the jurors are probably thinking the same thing. What is it? Why would she do this? Why? There's going to be a juror saying, why would she do this?
Yeah, I mean, I'm asking that myself. John Day, this was also very interesting. There was a moment in this trial where the prosecutor takes the band. Here's the issue. She, according to the defense, tied these bands very tight. But the Commonwealth is trying to make the point that she sat there and physically was holding it for 4 minutes, whereas the defense is saying that they believe she essentially tied these bands. And so the defense went up there. The Commonwealth went up there at one point and wrapped the band up, an actual exercise band, and then dropped it on the table. But what happened was it completely unraveled. And Kevin Reddington says they've got to get Lindsay tightening those bands 2 minutes, 3 minutes, 4 minutes. But when she drops it on the table, the bands just, you saw it, they just sprung open. It was a gloves won't fit moment. Like if the glove doesn't fit, you must acquit. And he said it was a demonstration that backfired on the Commonwealth. I thought that was interesting. Your take. Let me unmute you here. I'm sorry. Well, let me.
All right.
Go ahead, Joe.
Yeah. I mean, you don't do that stuff. First of all, don't try the theatrics. What are the odds it's going to backfire? I mean, it did, and Reddington knows how to play it. And that's an image that's going to, this is a visual case. This is a case where the jurors are going to remember every visual moment that was not just testimony from the witness stand. And they're going to remember moments like that subconsciously or not. So don't do that stuff if you're a prosecutor. And Tim's point, again, is right. They don't have a story the way that Reddington has a story. They don't need it. It's not required, but the jurors want the explanation that the Commonwealth has not been able to provide to close it out with. So again, I think that's very likely why it's hung, or you're going to have an acquittal.
Yeah, and Tim, I think in fairness to Reddington, he's 75 or 76 years old. He looked exhausted, rightfully so. The guy should be, retired. So the jurors don't have to cut him slack, but on our end, maybe you cut him a little bit of slack. But when he talked about the bands, he said, look, this, again, he brought up, it shows manipulation of the government. He goes, this prosecution is a mess. They say that she didn't tie a knot. And then he goes about how Patrick had to actually untie the knot when he gets there. And he says they want those 4 minutes where she's strangling them, but it doesn't exist. From there, he pivots to she's chained to her bed. She didn't have the fluffy restraints. And that's where kind of thinking to myself, okay, this woman just kills her 3 kids. Like, I'm not that concerned about the restraints. And he goes on to talk about big men with guns and badges, and she's paralyzed, but they want to make sure she didn't run out. I'm very open about being pro law enforcement. I don't know what kind of points that got, because people are going to know, look, she had to be protected. Police had her in custody. They had to keep watch on her. And am I going to really feel awful that she's got metal handcuffs and not fluffy handcuffs? I just thought he wasted a little bit of time with that. And real quick, Calvin here, Lindsay Clancy is guilty. Tough case. I suffer from depression, and I know how it can change your perspective on life. Unless you've been through it, I don't think anyone really knows what it's like. That's another issue, and it's going to be interesting to see if these jurors have that or not. But Tim, big bad cops, I get it. He's a defense attorney. You guys like to invoke that, but here, I think he could have spent his time elsewhere.
Hey, listen, he is 75. He's tried a 5-week case by himself. And you get to the point of, you reach the crescendo, right? And the closing is, but you're worn out. I mean, it's a lot of work, a lot of responsibility, making those objections, decisions, witnesses, cross-examine. It wears you out mentally and physically. So we do need to give him a little slack. I think he knew the case. He does not like to be limited by a script. He's told people that he's been doing it too long. and it's a feel. He says it's his gut. And I think he truly believed he wanted to show that this was a manipulation, lack of investigation. She was a good girl, and that the medicine and medical community let her down, and that there's no way they can prove beyond a reasonable doubt. And I think that's his strength. That's his case. And sometimes he wanders off, and he is sarcastic. He did it. The quarter thing, I think, backfired on him. I think the judge got mad at him about that. The jurors are going to laugh about it in the jury room. They'll laugh about it later on. And I thought the prosecution, when she picked up the quarter, I think that was a great point. But you don't want the judge to interrupt you. But, and John probably knows this, you get caught in the middle of it. You want to make sure you make all your points. So you have an outline of things you have to say. You want to check them off. You don't want to miss something in closing because you could sway a jury. But you also don't want to be tied to a script. That's the worst thing you could do. It shows you're just a mechanic, and that doesn't sell juries.
Yeah, we've passed the 1 hour mark with these jurors. Does this go for a few hours? Does it go for a few days? It is anybody's guess, but we will find out in due time. If you're just joining us, apparently the jury foreperson is an older woman in her 60s. The oldest woman who was on that panel has been chosen, according to reports, to be the jury foreperson. John Day, I guess maybe I'm being petty, and I don't encourage anyone to write like this. I don't like linear trains of thoughts, but in a closing, I think it's important. And so he goes and he talks about the big bad police, at the hospital. But then he goes back to the medical side of things with the doctors. And then he comes back a minute or so later to him finding this bottle of pills when he's with Patrick in the house. And it was hard for me to follow the train of thought that he was having, because he's going police, law enforcement investigation. Then he's going medical doctors, failed medical treatment, back to these police now. Should he have been more linear in his presentation and closings?
Well, I think Tim's point, I mean, you're wiped out at that point, and he is doing it by himself. And closing, you want, as you said, you want to make sure you hit all the points. And as you're doing it, you're realizing, wait, I haven't talked about that. And you can get a little sloppy, especially in a case like this that's been so intense. And he doesn't have backup the way that you often do in that situation. So yeah, if he's being a little less linear, I mean, I've been there, but he may feel somewhat confident in that he's going up. He feels like, when you're watching, we haven't seen the jurors' faces. It's an audience of these 12, 18 people that, I mean, if you're standing there at the podium looking at them, you have a sense of who's with you and who is not with you. Who's got their arms crossed and is looking away, and who's looking at you attentively, who's writing something in a notebook, who is got their eyes glazed over. So he's focused on his audience. He may have had too much of a agenda he wanted to get through and missed a few points. But one thing we all haven't seen that he has seen and the prosecutors have seen, and he's going to be better at judging who he's got by now anyway. And that's going to be fascinating.
Yeah, all salient points there. Bree Kelly is a new YouTube member. A lot of new people coming in until YouTube tries to destroy STS, and they will pay the price. But that's a whole other. Don't get me fired up again. We do a live show, 7 p.m. Eastern time, with the best guests in true crime. That is our daily routine. Three guests every night, Monday through Friday. But as you can see, we cover the biggest trials. The show is named after my mother, who is a child Holocaust survivor, and I'm always trying to survive her wrath and indignation, hence Surviving the Survivor. She usually joins Friday, but she's out partying and globetrotting. She'll be back. And we cover these trials. So please like and subscribe. We've got an active Patreon page as well. Tim, one of the one moment that I look back to where Lindsay Clancy kind of flipped a switch a little bit is when the prosecutors were talking about birthday anniversaries of the kids while she's at Tewksbury, and the fact that she wasn't crying and wasn't crawled up in a ball and she was actually laughing and playing dominoes, it was something that really rubbed her the wrong way. And at this point, Reddington goes, she's a good kid, using the word kid again. She's a beautiful soul. And he pivots. He goes, the parents come up. They're in, they want to take care of her. And the Commonwealth brings this up. And he says, sometimes they do have dinner. God forbid she meets with her parents and they laugh a little bit, that she's not curled up in this fetal position. And they're trying to manipulate the situation using these kids' birthdays. That they were looking through the logs, trying to find something. And he says the words manipulation and refers to his client again as a kid. So that was a recurring theme. And he was taking a shot back at the Commonwealth. Don't come after my client. She is living her life in a horrible place in this psych hospital. And just because her parents were there, she is allowed to maybe laugh again. Some people might not agree with that. But that was the argument he was making. Is that a wise use of his time there?
Well, he had to mention it because it was something that the jurors at the prosecution noted. And it's a good point, good investigative point, a good prosecutorial point. A mother who loses a child will never forget the birth date of their child. And the way this happened, you think now she's not suffering from postpartum. She's under medical care and she's getting mental health. But yeah, he had to address it by saying these people were coming. What is she not supposed to do? He could have argued, hey, the parents went there because it was the anniversary of their birthday and wanted to take her mind off of it and get her. He probably should have said that, but it is a point he had to make.
Yeah. You hear, John Day, that you don't take the experts. If you don't believe what they're saying, they're experts, but you don't have to listen to what they're telling you. And then he says, we had Dr. Philip Resnick. He has a world record for treating people who killed their children, which is a bizarre way to say it, but in essence saying he is the expert. He then says, look, the Commonwealth expert, Kirk Heilbrunn, said it's possible, that suggests reasonable doubt, that she was in some psychotic state. He said, this guy, Avram Mack, I suggest you don't even listen to that guy. And he said the other expert agreed with me. He goes, what kind of expert is that? He goes, he agreed with me just yesterday. And then he ends it by saying, look, this young lady, he says, this young lady is not guilty because she was suffering from mental disease and defect. And that's how he ends it. Is that a powerful way to close it out?
Yeah, I mean, my experience is mental health experts, in particular jurors, they cherry pick if they're already got some sense of what they want to hear, and it's just bolstering their own initial concepts. I've rarely found a juror who said, well, this one expert totally changed my mind. I mean, it's especially in a lineup like this. I think the defense, I think he scored a lot of points on that. But I think, you've got to at least try to explain why the other side's guys don't know what they're talking about. But they go into it. I think jurors, at least the ones I've talked to, they go into it pretty with some preconception, and then they just use what the expert says to help them decide that they're right. So,
yeah.
Tim Jansen, and I'm going to go now on to the Commonwealth, and I'll do this part quicker. Not because I'm biased, because I think it's been a long morning for everyone. But Tim, look at this. Shanna Gardner continued until next year. I know you plan to cover that. Yeah, I had heard something was going on. I wonder why, but I have to check that out. I'm going to cover something else. Interesting. It's been a weird day. So Tim Jansen, let me start with you. With you, the ADA gets up, the prosecutor, and says, "Look, by the way, totally kind of different tone of voice, not combative at all, the way we had heard her, soft-spoken, and clear." And she said, "Look, there's no dispute she was suffering from mental illness. She tried to kill herself, but that's not the issue in this trial. This is not a trial about mental health. It is about whether or not she knew right from wrong." And right then and there, she just encapsulated everything. And I thought she did it right out of the gates. Smart to characterize it that way or
I
structure
think
it
she
that way.
did. And I think that her presentation was much better. And I think it was more matter of fact. We are here on behalf of the Commonwealth instead of some angry woman. I think, and they were justifying why they brought these charges, and her demeanor was appropriate. And she had facts that outlined some of the arguments she was making about she wanted to do it on her own time, her own way. And they mentioned she wasn't getting help. They gave her 3 alternative: inpatient, partial hospitalization, or outpatient. She didn't want to take any of those. She turned them all down. She was making good points and citing to evidence in the record.
John Day, then from ADA Sprague here, she goes on to say, Lindsay Clancy had more than most. She had healthcare insurance, she had prescription insurance, and vast majority of people don't have this. 18 weeks of maternity leave, but she had depression. And when you look at the medications, you know, there's been all this talk of over medicating. A lot of her pill bottles didn't even have pills missing. Abuse bar, there were only 2 missing. This one, there was none missing. That one, there was none missing. The defense wants you to think she was begging for help, but she didn't want to get better. She's sort of shaming, accusatory of Lindsay Clancy. Could that backfire?
Yeah, it cuts both ways, doesn't it? I mean, what normal person, to use that term loosely, wouldn't be taking? I mean, you know, you're basically bolstering the defense argument that this is so out of the realm of understanding that it had to be something that coincides with the defense theory. I mean, I think there's a danger in going down that line because they still can't answer, okay, if that's the case, then why did it happen? That's basic. It's simple.
Look at this. I wonder if there's jurors like this. Grid, I've completely changed my opinion from the beginning of the trial. And do you care to share how, Grid? And we'll look for it. Are you now pro-Commonwealth? Are you pro-defense? Interesting. Tim Jansen, the Commonwealth says, look, she wanted to get better on her own terms. She wanted to go back to who she was. It's relatable to try to look for that magic pill, but no magic pill exists. And by the way, she had options. It was the exact opposite of turning her away. We kept hearing that she was turned away from this place and that place. She said they offered her a bed at McLean and she turned it down. Some people say that, you know, this was an outright lie. I don't know. And then she blames the defendant here, saying she does not tell a single provider. And you know why she doesn't tell a single provider that she's having these feelings? Because her kids could be taken away. And you know what that is? That's a rational thought. And, you know, that had come up before. But again, she stated it so clearly. I was like, whoa, she's making a good point.
She made a great point that she was so deliberate and not giving all the information to the doctors. The doctors couldn't give her the appropriate medicine and incarcerate her or put her inpatient because she purposely didn't say she was going to hurt herself or have any threats towards the kids. And she says that's a rational thought that she would underplay how bad she was. That's a good point for the prosecution.
Yeah, for a line here, she also asked people if they could hear her thoughts, so it gets very complicated. This is why they've got to go through the evidence, obviously, which is hopefully what they are doing right now. Hopefully they're getting a bite to eat as well. Do we know how many of the final jurors were men? It is 9, from what we were told, 9 women and 3 men, and the oldest woman who was there is allegedly the jury foreperson. There is a media stakeout going on. I don't think Kevin Reddington is going to speak. Maybe when he leaves for the day. Right now, he's probably hiding inside the cafeteria or somewhere inside that courthouse.
No cafeteria in that courthouse.
Really? Well, that's a problem for Reddington then. So John Day, she goes on here. She says, you know, as far as suicidal ideation, she told everyone no, and frames it as Lindsay Clancy, was controlling the presentation. The most drugs she was ever on. You know, don't believe the 13 number you keep hearing. She didn't say that. If it was me, I would have said that, but she didn't say that. But she said the most drugs she was ever on at one time were 2 to 3 drugs, and goes on to say that unfortunately with mental health, there is no CAT scan or MRI. You have to rely on what the patient is telling you. And again, John, putting the onus on the defendant, which I thought was smart.
Yeah, but again, you know, what they're trying to do is explain away something where they can't finally give the final explanation, the one explanation the jurors want. And I just think that that kind of detail on a case where there's at least some motive, when there's some explanation, is certainly a good idea. In this case, where does it get them? I mean, if, say that everybody, the jurors buy this line going down every point that the prosecutors are making, but the final point that the jurors are looking for, they can't land. And that's a problem in that kind of a deal. And I think the defense experts made a really good case for people being how planning and activity that's consistent with planning and you know, having an agenda is not necessarily inconsistent with severe mental illness. I mean, you don't have to be wild-eyed and raving every time that somebody who is exceptionally mentally ill makes a plan. I mean, they said that's certainly consistent, and there's no reason to think that that's an indicator that it's not consistent with being too ill to make the distinction between right and wrong.
Tim, from Diane Marquez here, I guess, I don't know, I'll leave it at that. Where does Lindsay go while waiting? I assume there's some sort of holding cell or room inside the courthouse. She's there because obviously, number one, she's in a wheelchair. Number two, Tewksbury is far. And if they come back, she needs to be there, right?
Yeah, what the court does is tells all the lawyers, you got to be within 10 or 15 minutes. Give the clerk your cell phone. There's no cafeteria there, so maybe he's in some office or some room and going to get food delivered. But the defendant is going to be probably downstairs in a holding cell. They're probably going to feed her lunch when they feed the jury, give her something. Maybe she'll have her priest will be there with her, but you can't really go too far, because the juror could have a question at any time. And, you know, if you're not there, the judge is going to be all over you. A DA, just go to their office. Their office is in the building.
Yeah. Tiffany here. How can a mentally ill person make a rational choice? Maybe these closings are irrelevant. Maybe the whole trial, maybe these jurors are just asking them this question. How can a mentally ill person make a rational choice? Followed by Ray of Light, who I've gotten to meet during this trial. Everyone seemed, look at this guy, smiling, happy. We need to see more rays of lights. He could have called it, you know, if it was me, I might be Ray of Dimness, but not Ray. Ray is Ray of Light. Everyone seems to be deciding this based on their own interpretation of mental illness, and most of us have the wrong interpretation. That is probably true. What's interesting is I think that almost everyone knows someone who has suffered with some mental illness, whether it's anxiety, depression, this, that, whatever it is. Someone knows somebody. It's like knowing somebody who's had cancer. A lot of people suffer through mental illness. But John Day, we're going to wrap this in a second. Commonwealth goes on to say, look, she denied hearing voices. There were no signs of psychosis. Were all the doctors wrong? I thought it was smart. And then she pivots to December into January. All indications were she was getting better. She's sleeping better. She's feeling better. She still says she's not completely herself, but she's moving in the right direction. And even her mother said, I'm glad to see you doing so much better. But what I didn't like, John, is after the mother comment, I'm glad to see you doing so much better, in a text, the ADA takes a shot at the mother, which I don't think is ever a good idea, and says, but now this mom wants you to believe that the daughter was lying to her. How careful do you have to be with that, John, to accuse a mother? This is the same woman who I think, no, this is not the same woman, because it was Patrick Clancy's mother, whether the mortal sin issue came up.
Yeah.
But you're treading on thin ice there when you're going after anyone's mother, I think. Oh, hang on a sec, John. Let me unmute. Go ahead, John.
It would just be consistent with Reddington's argument that the prosecution is malicious here. And you have to be very skeptical of what they're saying. And they're being manipulative and so on. But I'm just wondering if in this 9-3 split, if the men in that jury room are going to be remarkably quiet during the discussions, you know?
Take
I
a
don't
back
know.
seat because it's not an issue they can deal with.
Exactly.
It's kind of
Joel,
funny.
funny,
Yeah.
Joel, the second day, the day of the openings, we were in the courtroom and we were trying to figure out who the foreperson was going to be. And someone picked out the older woman because she was so attentive and taking so many notes. And they
Yeah.
thought that she might be the foreperson. And looks like she is.
Yeah. John brings up a really good point now that he mentions it. If I'm in a room with 9 women and we're talking about postpartum issues, I'm going to feel a little out of place there, right? I'm going to defer. That's interesting. I hadn't really thought of it that way. But good point, John Day. Seriously, all guys, here we go, trying to mansplain female mental health. Great providers would have known there was more than she was saying. They failed. So, I mean, Tim Jansen, you're sitting there, and the 67-year-old jury foreperson is like, why are you trying to mansplain this to me, Tim? And you're just going to shut the hell up and let the women do their thing, right?
Well, that's what I don't understand. You got a mentally ill person and you're the doctor and you're relying on them to give you information so you can treat them. How that's asinine. If they're mentally ill, they're probably not going to be able to tell you everything that you need to know. And that you should be looking at records, looking at this and looking at that, instead of relying on a mental ill patient in front of you. But that's what they seem to be saying. They rely on the mental health person.
Yeah, I was actually talking at soccer practice 3 different moms last night, and I just knew to shut the hell up. I just let them debate it. Because what am I going to say? I don't know. I mean, these are all women that have given birth. Min Benjamin with a super chat that I saw. I don't know it by heart. It was taken down, but it was basically it's an indictment of women with here we go. This whole trial is a witch hunt stemming from a complete lack of understanding of female postpartum mental health. I mean, John Day, they could never have a trial where they exclude male jurors, could they? I mean, what do we know about this?
Well, you know what's going on in that room. It's like every juror is going to revert back to their very strict 4th grade teacher, the woman who's the foreperson here.
Yeah.
It sounds like she's going to control the room like, it's going to be reversion to a time before where you deferred to your teacher and you listened to what she had to say. So whatever she comes down on this thing, if she's the one who was taking copious notes, she's the one who's going to be explaining and filling in the blanks when they're having those discussions, and they're going to be deferring to her. So it's going to be fascinating after the fact to hear what the jurors have said about deliberations and who said what and how it broke down. That's just one of the most interesting parts of doing trial work is hearing what worked, what landed, and what didn't work, and why they didn't like you or they liked you.
Now, on top of all the YouTube stress, now I'm picturing myself in this jury room being yelled at by women because I know nothing about postpartum. John's right. I would just sit there and just, I don't know, stare out the window and just say, yeah, just count me in for whatever vote you guys want. I would just tap out. Tim Jansen. This was toward the very end here. This was interesting and also very effective, very straightforward, but I don't think I had heard them present it this way, but the Commonwealth says, look, Patrick comes home. He sees Lindsay. She's not actively bleeding. Again, questioning the quote unquote real suicide attempt, but they get it in there. And he asks her, what did you do? She says, I tried to kill myself. She didn't say, I heard a voice. I mean, that's the clearest that they've presented it up to this point, and I thought it was effective. I mean, it cuts so many ways, though, because also people with psychosis aren't sharing that they're hearing the voice, but her first instinct is to say, it was about me. I tried to kill myself, and doesn't say anything else about anything. Is that a win in that moment for the Commonwealth?
I don't think so, because I heard the 911 call, and there was no conversation heard of Lindsay saying anything. You heard him talking to her, but you didn't really hear any response from her. and he keeps asking questions and talking to the 911, but there was no clear communication. And then you look at her injuries and you look at her body temperature. I don't buy the government's theory that she deteriorated between the time Clancy, Patrick talked to her and by the time the EMS got there and they said she could not communicate at all. I don't buy that because I think they were there within minutes, you know? So I don't buy that at all.
Yeah. Let's round this out here. John Day, this was sort of the very tail end of the argument. And she says, 2 days after this, on the 26th, she sort of comes to after being in what has been described as a coma state and asks, do I have a lawyer? And that's right where they sort of close out and say, look, this is essentially not adding up. You need to come to your own conclusion. But this is a woman who was depressed, yes, but not psychotic. And she knew right from wrong.
I think the defense made a good counter to that with explanations about going in and out and how, if you want to be consistent, the prosecution wants everything to be consistent in this case. And at the end of the day, the jurors are not going to be able to make a rational explanation that's consistent with the prosecution's argument, that everything should fall into place, that this was somehow calculated and qualifies for first-degree murder or second-degree murder. The defense explained that, you don't have to be consistent, that mental illness is not a consistent state, and severe mental illness, as in this case, in their view, you can have things like planning, organization, rational thought that's mixed in with irrational thought. It still doesn't give the jurors a reason to buy everything about the prosecution's argument, because there's still why.
Yeah, sorry, I clipped you there. John Day, criminal defense, former prosecutor, coming to us from Santa Fe, New Mexico. Appreciate you being here. John Day, we are now 1 hour and 32 minutes and 3 seconds into deliberations, unless they took a lunch, but we're on the verdict watch here. What is your prognostication? Do we get word today? You think there's a question? Does a jury come back at all? And when do you think we get an actual verdict here, if we get one?
I don't think they want to spend the weekend doing this.
So are you leaning towards tomorrow, or you think today?
Tomorrow, something by tomorrow afternoon.
Yeah.
But they don't want to be doing this Saturday and Sunday.
I agree. John, huge thanks. Appreciate you being here. Great point. Someone's asking, why are there no women on this panel? Because originally it was just Tim and I, and Tim is not a woman. Then I said, let's get someone else in. And Steve got John Day. But we're doing, I believe, a wrap-up show at 5. I am so discombobulated from the YouTube trauma that I experienced that we'll get back on it. But we'll come back later today with a kind of a proper wrap-up show on all this. He is R. Timothy Jansen, the letter R, O-U-R, Tallahassee criminal defense attorney and former federal prosecutor. Tim, you get the last word. How does this all end? We're at the tail end right now, Tim.
Well, the Commonwealth had to attack Dr. Resnick because they knew, but they really didn't. They tried to set some red flags. They never came out and said Dr. Resnick's wrong and our experts are right. They kind of bypassed that. So they left that hanging. They didn't attack him. I still think it's going to be hard for them to prosecute this woman, knowing how we got to where we are, why a woman would kill her her 3 kids. And I don't think they proved it. And I think you're going to have jurors who are going to say, I think she's guilty. And I think she had mental illness. And I just think they're not going to reach a verdict. They might get an Allen charge tomorrow or Monday. I don't know if he's going to have them come in on Saturday and Sunday. Normally they don't do that because you have to pay for clerk. You got to pay for security, and it's overtime pay. So they probably would come back Monday, but I don't see any quick verdict in this case on a 5-week trial.
We are going to find out. I cannot end this stream, so I'm going to thank Tim and John Day once again. I'll bounce you guys out. Feel free to bounce out on your own. Appreciate you guys being here. Let me just bring in the female voice, the voice of the COE, which at times is comforting. And like my mom, at times creates palpitations. COE, you're here with audio only. What do we do now? Please guide me. Do we, does everyone stay in the chat and chat? And that's why it's called a chat and not a quiet until we get, can we bring up the courtroom? What's happening, COE?
Yeah, we're going to keep this stream up for everyone since it is a verdict watch stream. You can see the clock there. We're going to keep that. That's a live feed from the
How does
courtroom.
someone as tiny as you have such a powerful voice? It's crazy. It's 5'2", soaking wet, and this booming voice. But go on.
We're going to keep this stream up, and this stream will only end today when jurors go home and finish deliberating. We, I believe, may have a 5 p.m. show, Joel. So should jurors be allowed to stay past their regular hour, which I think is like 4 or 5 p.m., then we would have dual streams, but we'll address that later as the day continues, depending on when jurors deliberate until.
I don't want to be dramatic, but I feel like I have to go to like an urgent care and get like vitamin supplementation, liquid IVs, or get like I can barely breathe. This was too stressful.
Okay. Well, luckily you were just sitting there through it all, but we're fine. We're back. We're good.
You know how I tell you I watch the UFC? We can have this
conversation off air.
You know how I tell you I watch the UFC and I've got to retire from fighting. It's like the fight ends at 1 and I'm like, it's like that times a million. I feel like I need intubation or vitamin drips or something. I don't know if I can do a 5 o'clock show. This just took too much of a toll on me. I can't express how much I despise YouTube. I hope the algorithm, I hope you hear that.
But also, thank you, YouTube. We appreciate you allowing us to be here. Joel, we can have this convo off air.
I don't appreciate them at all. I appreciate them.
I'm going to mute myself, but I'm here if anyone needs me.
COE, I'm going to call you in a second. If you don't know, for zero reason, a lot of different streams at the peak of the closing arguments were thrown offline, and it sent me into a spiral of which I don't know that I can get out of. Rosie appears worried. Joel, take a break. West here. Joel, you have to do a 5 p.m. show. What if I can't? What if I just can't? I will try. Look at this, Dolly. How can you not love Dolly? Dolly Parton no longer with us. Another reason to not do a show. So depressing. What a depressing week. Joel, please order lunch, including fresh organic juice. Does Coca-Cola count as fresh organic juice? Asking for a friend. What now? The trial I was going to cover next is that's not happening. So please, survivingthesurvivor@gmail.com. Let me know if are there any other big trials that are starting up in the next, let's say, 4 weeks. If there's a trial you want me to cover, it appears that I am wide open right now, and I want to cover another trial. Please, please, let me know. Karm would certainly yell at me for not doing a 5 p.m. show. Don't worry, I texted Karm and let her know my feelings about tech companies, and she's gonna get it. And she's going to go, Joel, why do you share this with me? What can I do about this, Joel? To which I will say, you're my mother. You're supposed to help me with everything, including YouTube. This is sort of partially true. The real victim here is Joel. Your mom called. That's because I texted her. And I was really upset about it. Joel, you need to meditate. I don't know how much, I used to say to people, like, if stress really caused like thinning hair, I would have been bald at 16, but I just don't know how much my body can take of this. The COE will be fine. I take it much more to heart. People think it's a money thing. It's not a money thing. I put my heart and soul into this, and and you guys come to watch closings, and then suddenly we get derailed, and it just drives me crazy. It just drives me crazy. Our future is screwed, man. Everything is going to be AI. My name is Jerf. What a baby Joel is. Look, there are going to be no more humans running anything. I already have cars. Thank you, Tassie. I already have cars driving around Miami with no drivers. So somebody big, was it Bill Gates? One of these guys just said basically the world's over because of AI. There's going to be a total lack of employment. And look, it's already happening. I've got an algorithm deciding whether or not I exist or not. I'd like to smack that algorithm right in the face is what I'd like to do. Wish you could smack an algorithm. You have no idea. My wife is a patient woman. I would not want to deal with me. I'm the first to admit it. I would never want to deal with me.
Joel,
COE,
since you're discussing the algorithm, can you remind everyone to subscribe and like, and remind everyone that we also have an STS membership available here on YouTube as well as Patreon?
Yeah, I think you said it all. I think it would carry a lot more weight coming from you, but please subscribe, like. We've also got some kind of YouTube membership, and we've got other members. We got Patreon. We got everything. We got COE shirts in the merch store. Everyone's the chief of everything. STS crew and friends. Why don't you give it a rest until tomorrow afternoon? Devil's lettuce. Just don't go do the devil's lettuce. I don't. I probably should. Bice wants me to write a comedy novel. I can understand. I annoy myself. I tell Karm that, like, I'm annoying. It's annoying. I'm annoying myself right now because I'm obsessing about this. But it's you guys rely on STS to bring you closings, and then some algorithm decides that they're going to just shut us down midstream, and it's you can't. That's what frustrates me. You can't call like 1-800 YouTube. Like, you literally can't call anyone at YouTube. Joe, you need a pina colada. You know what's crazy? There's a boba place right before me, and they sell pina colada bobas, and they're so good. And I might treat my non-alcoholic, by the way. Assistant State Attorney Christina Stifler said they plan to take Tennant and Gardner cases back to the grand jury to try the two together. Jeez, Gardner's trial to begin with jury selection on May 3rd of 2027. If there is a trial you want me to cover soon, like in 4 weeks, please email us, survivingthesurvivor at gmail.com, survivingthesurvivor at gmail.com. There are COE shirts, or there used to be, in the merch store for Joel's Wellness Fund from North. You know what would do me, like, would immediately relax me, is if I could just pet a horse's muzzle or give it some carrots. You know how they slop it up with those big hairy lips of theirs? I would love to pet a horse right now. It would immediately relax me. You can pet your 3 dogs at home. 1-800-FUYT. I wish that was a real number. I really do. No, you're not dropping them off here. I'm coming home right now. We're on verdict watch. COE, I assume one of us is watching this to know if they come back. I've got to leave the stream up, so I'm just going to bounce myself up. Love you, America. Love you, Plymouth, Massachusetts. Cora, Dawson, Callan is what it is all about. These jurors, I do not envy them. They have a really difficult job ahead of them. We're going to leave the stream up. You guys can talk amongst yourselves here. The COE and I will pop in periodically, and appreciate that. We saw that from Horse Lover. I will bounce myself out of here, and the stream remains up. Even when we're not here, STS is here. Love you all. Thanks for dealing with my neurosis. Just her major depressive episode diagnosis was enough to get her to a safe place. Didn't have to get all the way to psychosis again. Failed. That is from Becky. A final comment. And it is appropriate that a woman has this is probably true too. It's appropriate that another woman has the final word. See you guys in a little bit. Love you all.
All right. What we're going to do is I'm going to bring the jury back and just excuse them till tomorrow morning. Okay? All right. Yeah.
Court, all rise. Jurors entering. This court's now in session. Be seated.
Your Honor, present before the court, we have 12 deliberating jurors and 6 alternates in the matter of Commonwealth versus Lindsay, Clancy. All other parties are present.
All right. Thank you, Madam Clerk.
You're welcome.
What I wanted to bring you in. It's been a long day for everyone. And so what I'm going to do is excuse all of you till tomorrow morning, 9 o'clock. I just want to, as you can imagine, I want to reiterate those instructions. Now you are either deliberating jurors or alternates, possibly to deliberate. So I can't stress it even more than I have for the last 5 weeks. Don't read anything about this case. Don't talk about this case with anyone, even at home. Don't listen to anything. Just put this out of your head. Come back here tomorrow morning. We'll start at 9 o'clock. What'll happen is we'll have you come in. I'll bring you in. I'll ask you those questions. I'll just turn you right around and have you back deliberating. All right? And so with that, with my thanks to everyone, excuse you till tomorrow morning. Thank you.
Court, all rise.
Jurors have exited the courtroom. This court's in session.
All right.
Please be seated.
Anything we need to address before tomorrow? Counsel. Thank you, everyone. We'll be in recess till tomorrow. Thank you.
Court, all rise.
Hey everyone, it's the COE. That's it for the day. I do want to remind everyone that we do have a 5 p.m. Eastern time show. We're redirecting you there, but it won't start for another 50 minutes. The verdict clock stopped at 3 hours, 32 minutes, and 26 seconds. Again, we will be live with a Verdict Watch live stream all day tomorrow as long as the jurors are deliberating. And we do have a 5 p.m. Eastern time show tonight with the STS host, Joel Waldman, as well as 3 new best guests. Thanks so much and see you soon.